Okay, what our program is for today is teaching about religion in public schools, the how and why. And we, as in California, religion now is part of the curriculum. And so it's very significant that we are good at doing this, because it's especially at middle school level, but it's across the board if you look carefully at things. But I'm Peg Hill, or Margaret Hill, they sometimes call me, and I've been working in this for 25 years, maybe as much as 30. I don't know. After a while, you don't count the days much. When I retired from teaching, then I tried to find someone who would work with me, work with the California 3Rs Project, which was the name of the organization that we used in the state of California to be of assistance to school districts and to individual schools if there was an issue that they didn't know how to solve. And when I left the public school system, then Constitutional Rights Foundation stepped up to be our leader. And we were able to come by that with a great deal of benefit, because the Constitutional Rights Foundation is exactly the right group that knows enough about the constitutional history of religion and has a staff and a whole bunch of resources. And that's why I look forward to introducing Damon in just a few minutes. That kind of wanted for the group to think about the fact that the history social science curriculum, as I said a minute ago, has a whole bunch of world religions integrated throughout, especially in grade 6 and 7. And then in grade 11, there's not quite as many, but there's a significant emphasis on Islam in the 11th grade. So it's very important that we understand why did they do that. That hadn't been part of the way the curriculum worked before. But the issue is culture and religion are intertwined. And if you don't know a little bit about religion, the culture of another country doesn't, or peoples don't make sense. And so that's the effort on the part of this, is to see the relationship between cultures and the belief structure within that system. And so I added a little to what I was going to say, and that was, it's become an issue in the United States as well, because we're seeing, because we have so many people from around the world, we have a lot of more diversity than we normally used to think about, which was basically race based. And now it's culture, it's all sorts of things. It's not just language, it's all of it. And so by having an understanding of the beliefs of a particular group of people, it really helps in being able to understand them and to solve problems with them. And that's a critical situation right now as we are looking at our own society, but it's all over the world. It's not just us. So the manner of including religion in the school curriculum includes holidays and dress codes in addition to the curriculum. It's all sorts of things. It's we were talking about dress codes for teachers as well as students. How does that all work out? And it's based on the First Amendment and interpretations of the meaning of that that have come up with lawsuits through the court system. So the courts have been engaged in dealing with religion in public schools for quite a long time. The current Supreme Court has changed some of those interpretations that we've been relying on. Now, we don't know where else it's going to go, but that's some of the reason for talking together today, because we're trying to understand where it's going so that we don't do the wrong thing or go the wrong direction in the schools. So I'm really pleased to introduce Damon Huss. He has just the right background. As I said earlier, I had to say it earlier because it's on my mind. He is very, very much the right person to be doing this work, because he's been a teacher and he's been an attorney, and he works a lot with the Constitution, with the Constitutional Rights Foundation, and has been for 15 years at least. So they don't see that grouping very often of skill sets, but he's got it, and he has great wisdom when it comes to talking with teachers about these kinds of issues. So Damon, the microphone is yours, and I'll sit quietly in the corner of the room and enjoy every minute of it. Okay.
All right. Well, gosh, thank you, Peg. Thank you for that generous introduction. Now I have to really step up to meet the level that you've mentioned. But it's great to be here. And one of the things is I love this work, and I was really happy. You mentioned when CRF was able to start administering the 3 R's project. I was really happy about it because the work that I was able to do with you for the few years before it came here to CRF in doing this, because I've always been interested. I was a history major. I love history. I've always been interested in world religions and the history of religion, and especially how I could see it in U.S. society, in U.S. history. And so I'm so happy to be part of the 3 R's project and to be working with you on this, and to have worked with you for so long on this. Peg's been my mentor in all of the work that the 3 R's project is about. And I do think that it's very fitting that the Constitutional Rights Foundation absorbed the 3 R's project because, as Peg mentioned, the First Amendment is at the center of everything that we do. So we'll talk a little bit more for the next few minutes about what the 3 R's project means, not just what it means for us to explain ourselves, but for you as educators here on this webinar to think about what this means for you in the school environment and how it really relates to the curriculum, as well as all the things Peg mentioned, the curriculum and also the school environment as well. I'm going to go back a little bit here to our opening slide, because one of the reasons that we're doing this webinar in particular, we talked last spring about wanting to do one in the fall, but one of the reasons why it's very important that we're doing it now is because you are here on this webinar in the midst of really monumental changes that are happening in the way religion is going to be expressed in schools. And two of the, this is just to give you a little hint of what we're talking about. The images here, you see an image, looks like it's a city council, and there's someone speaking at a podium in front of the city council, and that has to do with a case that we're going to be talking about, a Supreme Court case from 2014. That really is the case that's now established what can actually happen in schools. It had to do with local legislatures, city councils, and prayer at city councils, but it's now really become a fundamental case for how issues of prayer have been and may continue to be dealt with in public schools. And the way they have been dealt with because of that case, you see here the coach who's kneeling on a football field and praying. You may have already read about the case and heard about the case. It was huge news this summer, Kennedy versus Bremerton School District out of state of Washington, which has everything to do with prayer in schools and how that's changing right before our eyes, really. It has been changing over the years, but we're seeing it now just this year changing, and that's what we're going to talk about. It's going to be an important thing we talk about today. So I'm so glad that you've all introduced yourselves in the chat area. I love seeing the diversity of people who are here. We have middle school, we have high school, world history, and U.S. history. TOSA, and administrators, ethnic study, people representing ethnic studies, all of which is relevant to studying religion and teaching about religion. And the emphasis, of course, in the title you see here, teaching about religion, is important, because teaching about religion is what we're talking about in schools, rather than teaching religion itself or in any kind of devotional way. And with that, one of the things that you might have seen in emails that went out, Peg sent out an email, Jim also, I think, sent out the email, is what's your issue? Meaning, is there something that's happening in your school right now that is an issue related to religion? And what I'd like to do here, I'm going to drop this in the chat area for you. Oh, if I can, yeah, there's the chat, good, okay. What this means is, excuse my typing here. Plus I'm typing without my readers on, which is always risky. I think I did it well, okay. This is just a Google form, it's totally anonymous. What Peg and I often do when we present on what we've done, I think pretty much every time we've presented on the 3 Rs, is we like to collect information, totally anonymous, about something that's happening in your school or in your district, in your school community, related to religion, something that relates to it. It can be in the curriculum, any of the issues that Peg brought up related to dress code or related to prayer, related to guest speakers, whatever it might be. Is there something that's come up that is related to religion? Maybe it's something that sparked why you came to this webinar in particular. So as we're talking throughout this webinar, feel free to click, you can bookmark that link, click on it. You can share some issue that's been happening. If you want to write more than one in the paragraph, feel free. And our goal is that by the time, sometime later in this webinar, we'll be able to talk about those issues, and we'll talk about them in a general way. Now, as Peg mentioned, I am an attorney, but of course, nothing I am talking about today, nothing I would say is or should be construed as any kind of legal advice. Rather, what we're talking about are general issues that schools face, and schools have, public schools in particular, have faced over the decades, and they still are issues in our schools and are worth us exploring and talking about. So with that, oops, wait, what just happened there? That's not what I want. There we go. I want to give you a little background into the Constitutional Rights Foundation, where I work. We're a nonprofit, nonpartisan organization. We've been around since 1963. And what we do is we provide professional development and training for teachers. We also provide curriculum. My role here is as director of publications. So I work on all of our publications, including our Bill of Rights in Action magazine. I'll include a link for you at some point in this webinar for you to be able to subscribe to it. It's a free curricular magazine, and it's geared toward virtually all social studies teachers. We have lessons that are delivered to you quarterly on world history, as well as US history, and of course, civics and current events and US government. And I want to emphasize here that we're called Constitutional Rights Foundation, and the magazine is Bill of Rights in Action. But as I mentioned, we always want to include world history, because as a civic educational organization, we don't want world history teachers to feel like, oh, well, that relates to the Constitution, that relates to the amendments, that's US government. That's not really world history, but it really is. It's everything to do with world history, because of course we're part of law-related education and talking about policy, but of course, just being aware and being comfortable with, or I should say literate with, because we talk about literacy, to have a sort of cultural literacy and the diversity of cultures and the histories of different cultures in our society is a key part of civic education, and is a key part of understanding what it means to be part of a pluralistic and diverse society. So all of that is part of civic education. And of course, we have programs that you may have heard of, like California Mock Trial, do that program. We develop that. That's how I came to CRF, actually. And our Civic Action Project, which is a sort of a policy-based, service learning, experiential program for students to learn how to affect public policy in their local communities and schools. So that's what we are. I also want to mention that, of course, or emphasize, I should say, that we are a nonpartisan organization, and that will help explain some of the approaches that you'll see in the rest of this webinar. As a nonpartisan nonprofit, of course, we don't take stands on electoral politics or get involved in electoral politics. But it also means that as part of what we present, we want to present students with materials in order for them to develop their own critical thinking skills and their own abilities to analyze and to understand multiple perspectives and diverse perspectives on issues, and especially controversial issues too. So that's part of our nonpartisan approach. So what you're going to see here, I'm going to be presenting to you some of the history of the First Amendment, how it's been interpreted, what it means in schools, and you're going to see that from a nonpartisan perspective. I also want to mention that, oh, thank you, Laura, for dropping the subscription link to Bill of Rights in Action in the chat area. I also want to mention that at any time, feel free to drop chats or questions in the chat area, and hopefully we'll be able to take a look at those as we go as well. Peg mentioned a little bit about the background of the California 3 Rs project. So Peg, feel free to jump in at any time. But the 3 Rs stand for rights, responsibility, or responsibilities, and respect. And specifically, this is in relation to matters of religion and what we call freedom of conscience, of course, to include religious as well as non-religious worldviews. And freedom of conscience is a term that also originated with James Madison, or was used in the context of the US Bill of Rights with James Madison, that we have a freedom of conscience, we have a freedom of having what is called opinions on religion, which includes religious-based opinions. So we want to respect the rights, the freedom of religion as an inalienable right for everyone. We also have a responsibility to respect that right, to see that right as inalienable in others and those who are different from ourselves. And of course, respect means we can disagree with others. Obviously, we're going to have disagreements, and having different religious perspectives, different worldviews means you automatically have a disagreement about some aspect, but disagreement does not have to mean disavowal or complete polarization and feeling opposed to others. And that's what's important about what the 3 Rs means. Peg, is there anything you'd like to add to that?
Not really. You did a very good job, but I hope that people noticed that that's hard work to be able to take the responsibility for protecting someone else's rights and making sure that you're respecting other people's rights. That's probably the first thing that we would need to think about in a school site, because that respect piece has been hammered in our society and in the world lately as being something that means to a lot of people, those people don't matter. Mm-hmm. And we know better, don't we?
And what that means is, as I mentioned, literacy. The 3 Rs has really 2 goals. One is to increase constitutional literacy, our understanding and awareness, especially of where the Constitution, of course, relates to religion, which also dovetails with freedom of speech. And many of the cases related to freedom of speech have everything to do with religious freedom as well. So the First Amendment, the religion clauses within the First Amendment are crucially important. And also religious literacy, building the what I talked about before, people's and students' understanding of the diversity of worldviews that they encounter in their communities and in American society at large, writ large, are just as important. So constitutional literacy and religious literacy are our goals. The overarching goal we have here too, as we just touched on a minute ago, is despite our disagreements that we may have, to live with and understand our deepest differences in public schools. And Peg, you can correct me if I'm wrong, but this idea of living with our deepest differences, I think began with the work of Charles Haynes over the years, who has been an advisor to the California 3 R's project for many years. And he wrote about, in the 90s, about living with our deepest differences as one of the important goals of public school education in itself. And developing the constitutional and religious literacies are important ways to be able to do that. So that's the California 3 R's project. That's why we're here, and that's why we're bringing this webinar to you. What I'd like to do now is shift to talk specifically about what I mentioned a few minutes ago, and that's the development of the First Amendment and interpretations of the First Amendment and how it relates to all of you as educators in schools. So you see up here on your screen, we all know what this is. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, etc. That is the First Amendment, of course. Now, the First Amendment describes many of our fundamental freedoms, including the ones I just read, as well as, of course, freedom of speech, freedom of the press, the right to peaceable assembly, and to petition the government for redress of grievances. We're focusing, of course, on what are called the religion clauses. And that's the first part, the beginning of the First Amendment. And that is, of course, the Establishment Clause. Congress shall make, I have a little visitor here in my, so excuse me. The Establishment Clause, which is that Congress shall make no law respecting the establishment of religion, and the Free Exercise Clause. You have these two. A couple of things I want to point out is that the word shall in legal language is an imperative. It's something that's absolutely important. And so Congress shall make no law means Congress cannot, under any circumstances, make a law respecting the establishment of religion. Now, it also mentions Congress. So for many decades after the ratification of the Bill of Rights, it only applied really to the federal government, although the states had begun to disestablish religions and had disestablished religions all the way up into the early 19th century, about the 1820s. They had been disestablishing, meaning separating any particular religion, any particular Christian denomination, because they were all Christian majority states. Christianity is still the majority religion in the United States. But it was after that, in the later 19th century, that the First Amendment, along with many of the other amendments, had been incorporated into to affect state governments. So now state governments, as well as the federal government, are bound to follow the religion clauses. And what does that mean? Well, the two clauses I mentioned are establishment and free exercise. So the Establishment Clause, these are general principles I have up here. There's more specific interpretations that we'll talk about from the Supreme Court. But generally speaking, the Establishment Clause prohibits, again, federal and state and local governments from making any law that respects establishment of religion, which means quite literally creating a religion, or, but it also means establishing one particular religion. So they can't unduly favor one religion over any others, and also can't unduly favor religion over non-religion, or in the inverse, non-religion over religion. So there can't be a hostility, generally speaking, toward either religion or non-religion as the basis for laws or policies. The Free Exercise Clause protects the people's rights, so each person's right to accept any religious belief and participate in religious rituals, religious practices, and I emphasized here within limits, because the court has always said that Of course, we're free. When I say court, I mean the Supreme Court, the U.S. Supreme Court. We're free to, of course, hold any beliefs, but there are limits, of course, to the activities that one can do related to those beliefs, which is why in the later 19th century, the Supreme Court upheld a ban on polygamy as a religious right, in that particular case of the Mormon faith. So there are certain things that are illegal and they will remain illegal because even if there's a religious basis for people to want to perform them, to do them, there are some limits. The Free Exercise Clause also prohibits the government from substantially burdening any religious practice, of course, within limits, and also from mandating religious beliefs or practices. So the government can't mandate religious beliefs, but that in and of itself, as we'll see, can be very problematic and has come under different interpretations. What that means is the government mandating. Does that just mean the government can't coerce people to participate in certain religious practices, or has that meant that the government shouldn't even endorse or be shown to endorse certain religions or religious practices over others, which isn't coercive, but may also be alienating to some members of our communities? We'll see. So our goal in this constitutional literacy and for you as teachers is to make the First Amendment your friend. You want to be able to rely on the First Amendment. And when I say the First Amendment, I don't just mean just those words that I had highlighted in the actual First Amendment, but it includes all of the interpretations and the ways that it has been applied in schools over the decades. So here, in general, this touches on some of the things Peg talked about in her introduction. We have two different approaches that you can take in schools. One is an academic approach, and the other is a devotional approach. Now, here we're talking about public schools. So I'd like to hear from all of you. What do you think is the difference between taking an academic approach to teaching about religion and the devotional approach to teaching about religion? And you can share your answer in the chat area. You can just write a few words. What do you think is the difference between taking an academic approach to teaching about religion and a devotional approach? What would be the difference? And when I say there's two, these are two approaches you can take. They're not equally really accepted in schools. We should be clear about that. But what does it mean before we go any further between academic and devotional? There's no wrong answer, so go ahead and share whatever you think the answer might be in the chat area. If you'd like, you can unmute yourself too if you'd like to share it that way.
Pretty good.
Okay, so one of you said that academic is teaching the history related to the populations that practice a particular religion, so teaching the history. Devotional is promoting the belief in a particular religion. And another of you mentioned that the academic approach equals putting religion in context within the history of society, while the devotional approach equals teaching the specifics of the practice of that religion and having covered more about the impacts of that religion on everyday life. Also, we have an answer here. The academic approach, approach is about facts and the impact on historical events, whereas devotional is more faith-based. Good. So all of these are really getting, I think, at what we actually are talking about. I like the way Becky mentioned here that academic means the teaching the history related to populations and related to people who practice certain religions, whereas devotional is promoting the belief in a particular religion. That's a good way of summarizing the differences in those approaches. And from all of what I've read here, you have an understanding already that the academic approach is really suitable for schools. And as Paul mentioned, it's putting religion in context, and that's what teaching about religion in public schools is. It's putting it in context, in an academic context, rather than promoting or practicing religion in public schools. Private schools can be religious schools. I myself have taught at Jewish day schools where there's a separation between the secular studies, which is what I worked in, and the religious studies, for example. So private schools that are religious based can have, of course, religious education, but there's still an academic approach that's used in those schools for secular study, for English, language arts, history, etc. In public schools, we really are emphasizing the academic approach. And that's why what we're looking at through the First Amendment lens is that the academic approach is something that is constitutional, has traditionally been found constitutional, whereas the devotional approach in public schools has been found to be, generally speaking, not constitutional. Now, I want to emphasize we're talking about the ways that subjects are taught in the curriculum and also some of the practices in schools. You as educators taking an academic approach, even in teaching about religion, you're on pretty solid constitutional ground. If you take a devotional approach, which seems in any way that you might be proselytizing to students, then that has generally been seen as not constitutional. Now, before this summer, I would have left it at that. Things have started to change. And that just means that after the case of Kennedy versus Bremerton School District, remember the football coach who's praying on the field that you saw the picture of earlier, the limits of what the devotional approach are being tested. The Supreme Court, as we'll see, has said that that wasn't in any way coercive of students, but the limits are being tested, and I predict that the limits are going to continue to be tested by those who are employed in public schools, teachers and coaches, as well as administrators. Some may test those limits, and those limits have been tested, by the way, for decades. Every year you see at the beginning of the year, especially at the end of the year with graduation ceremonies, there are ways that religion has made its way into the agendas, and so they've been challenged in courts. Teachers can find themselves suddenly at the center of lawsuits where a devotional approach has been taken. And we'll see how that plays out over the coming months and the coming years after this Supreme Court case. Now, the cases that we're going to talk about now, in looking at a little bit of the history, often refer back to what the founders, the framers of the Constitution, particularly James Madison and Thomas Jefferson, because they wrote so much about religion and what religion meant in our government, that references to these really important documents are made in many of the cases throughout US history, the Supreme Court cases. The first one we'll talk about is from 1785, and it was authored by James Madison, and it's called the Memorial and Remonstrance Against Religious Assessments. What that referred to was in the state of Virginia at that time, there was a general tax that was going to be levied on all of the citizens within Virginia, and the tax was going to raise money specifically to support teachers of the Christian religion. So it was for the Christian faith. Madison thought that this tax was really a violation of important, what we would call separation of church and state principles. Now, that phrase, separation of church and state, was not really in the lexicon yet. Thomas Jefferson would say that almost 20 years later in a letter, and it's become one of the catchphrases that we now understand to describe how religion is treated in our laws and policies in the United States today. But as you can see here, Madison had some strong words against any kind of tax that would go to support a particular religion. And again, this is before the Constitution was even ratified. This is 1785. in the state of Virginia. And as you can see here, he likened this proposed establishment to the Inquisition in Europe. He said it's really, when we're talking about either punishing people for being members of minority faiths or taxing people to support a majority faith in the state, or any faith in the state, it's just a matter of degree different than the Inquisition, but it's on the same continuum. And it's oppression done in the name of a particular religion. And as he says here, it degrades from equal rank of citizens all those whose opinions in religion do not bend to those of the legislative authority. Meaning, if you're anybody in the state, now their opinion, they're being pushed into adopting the opinion of the majority, the opinion as it's proposed or as it exists within the legislature, which is of course done by majority rule. Now, thanks to Madison's efforts, the law didn't pass in Virginia, and actually set the stage for the next year when a law did pass called the Virginia Statute for Religious Freedom in 1786, which had been authored by Thomas Jefferson. Now, he actually drafted it back in 1779. He had finished his draft of this law for the state of Virginia, but it passed in 1786. And this was really one of the strongest, or this law contained some of the strongest language against the state mandating in any way that anybody participate in any particular religious belief or practice. And in fact, he specifically mentioned Judaism, Islam, and Hinduism as well as being faith groups that were represented in the state at that time, even though they were tiny minorities within the state, but that no minority religious group should feel compelled or be compelled in any way to support the majority. And as part of this, the Virginia Statute for Religious Freedom says here that all men shall be free to profess and by argument to maintain their opinions in matters of religion, and that the same shall in no wise diminish, enlarge, or affect their civil capacities. This is a really important principle that again was referred back to later by the Supreme Court many times, that your feeling and your sense and your status as being equals to others, regardless of your religious beliefs, is important to not only your religious equality, but your civil equality, your civil capacities, your sense of being a full member of civil society. In this case, in Virginia, although Jefferson's words and the statute had a strong impact on the Constitution itself. So between 1786 and 1788, the Constitution, of course, was adopted. It had to be ratified, though. So as we know, there was the history of the Federalist Papers, where Madison and Alexander Hamilton and John Jay wrote several Federalist Papers to convince members of the different states to ratify the Constitution. As we know today, obviously, it was a successful effort. So what James Madison wrote in Federalist 51 also reinforced that idea that we live in a pluralistic society where different religious views are expressed. And as he says here, in a free government, the security for civil rights must be the same as that for religious rights, echoing those words in the Virginia Statute for Religious Freedom, that your religious equality is also a reflection of what civil equality and your civil capacities are going to be within society. So he mentions here too the multiplicity of interests being the multiplicity of civil and also religious interests in society. So we're going to look at some Supreme Court cases. And again, if you have any questions on anything I've presented, go ahead and put that in the chat area. We're going to look at some Supreme Court cases, and I just want to get a few terms under our belt so that you know when I'm talking about the different decisions, you'll know what I'm referring to. So a majority opinion, of course, is what we often see on the Supreme Court. It's where a majority of the justices vote a certain way, and that becomes the majority opinion, that becomes the holding in a case. That's something that is really binding. The dissenting opinion, which is often called a minority opinion because it's a minority of justices who have that opinion, doesn't become binding, doesn't become the holding of the case, doesn't become something that other courts then have to follow after that. However, dissents can be extremely influential and very, very important. And sometimes you might see I treat the dissents as equally important in terms of their influence and in terms of the way that they are then cited, because obviously minority opinions are important with the court, but they're also important within our society as well. And respecting minority opinions, even if those minority opinions don't become the law of the land, but respecting them is one of the important foundations really of the constitutional system in and of itself. There are also opinions that the court issues, the Supreme Court issues, called plurality opinions. This can get very complicated. You learn about these in law school, and even reading about some of these cases, it can become confusing. But it's a plurality opinion is one where there's no clear majority. There may be multiple issues that the court was dealing with, and there's no clear majority on all of those issues. Some issues there may be a clear majority on, but other issues you may have the justices split. Maybe justices agreed with some part of a decision, but they dissent in other parts, and you might get 3, 4, 5, 6, even sometimes 6 different opinions. Some are concurring opinions, some are dissenting opinions, and a concurring opinion means justices might agree with the decision of the case, but they disagree with the reasoning. This can get very, I mentioned confusing, but also other justices later can rely on these opinions to a degree, and they can look to the reasoning in these opinions to try to help them form future opinions. But plurality opinions can be kind of thorny when we're trying to see, well, what's the clear rule here? We might not know. So 2 cases from the early 1960s are critically important for our understanding of religion in schools. These are often called the school prayer cases together. The first one from 1962 was Engel versus Vitale. The subject was specifically prayer in schools, and it had to do with schools actually leading students in a prayer that was written for, in the state legislature for schools to then read to their students and lead students in doing in schools. And the Supreme Court, a majority opinion on the Supreme Court, found that that is unconstitutional. That's a violation of the Establishment Clause of the First Amendment. And the opinion here mentions it's not sacrilegious or even anti-religious to say that that's a good separation we should have in public schools as government agencies. We should not have public schools dictating or mandating in any way what official prayers should be. And as the court said here in their majority opinion, that's a purely religious function. It should be left up to the people. It should be left up to the people and their religious clergy or their religious institutions to determine what kind of prayer, what kind of religious beliefs they want to have. It should nowhere be done by state actors in public schools, whether it's public school teachers, public school administrators. The very next year, there was a case that had a similar result, but related to the subject of Bible readings in schools. So this wasn't a prayer that was written by the state legislature or adopted by the state legislature in order to be put forth in schools, but it had to do with readings directly from the Bible, as well as the Lord's Prayer. And the Supreme Court came to a very similar decision saying that's a violation of the Establishment Clause. And very importantly, they articulated that what public schools should do in matters of religion should always be to promote neutrality, and for public schools to always take the position of neutrality when it comes to religion, whether in the curriculum or religious practices. Then a little less than 10 years later came what was a landmark decision in the case of Lemon versus Kurtzman. And the subject of this case was state reimbursement to private religious schools for teacher salaries, where I mentioned before, like I taught in a Jewish school. I taught in the secular studies department. So if you can imagine going back to 1971, this would be a teacher in a religious school, but teaching secular studies using the public school curriculum. And the state had a law that allowed reimbursements to those teachers for their salaries, even though they were in religious schools. It was challenged by this man, Alton Lemon, who was a social worker, and it was in the state of Pennsylvania. And the Supreme Court agreed with his challenge, ultimately, that the state can't reimburse religious schools, even for the teaching of secular subjects, because they are religious schools. And most importantly, the court came up with this test that's called the Lemon test. And the Lemon test had these 3 prongs, which means that any state law related to religion in schools, and related to religion in general, because it started to apply outside of schools as well, that the statute must have a secular purpose. There has to be a secular purpose for why a law related to religion is passed. It can't be specifically religious, like the thing that Madison was arguing against back in 1785. Also, the statute can't primarily advance or inhibit religion. So it can't be primarily pro-religion or primarily anti-religion, meaning its primary effect can't be pro-religion or anti-religion. And finally, there can't be any excessive entanglement between government and religion. So if the government, in this case, a school or school district, has to spend a lot of time determining what might be a good practice, what might not be a good practice, getting entangled, but also getting entangled in religious institutions, religious practitioners, then that's not good. If any of these prongs fails, then the law is unconstitutional. And this was, as you can imagine, a very strong law for separation of church and state. It established a bright line, really, between what was church and what was state in the context of schools particularly. In 1984, another law was passed called the Equal Access Act, and this has to do with clubs, mainly on campus. So you're at a public school, probably maybe at the schools where you work right now, there might be religious clubs, whether they're Christian clubs or otherwise. And the Equal Access Act, which passed with bipartisan support, very strong bipartisan support, even though it was originally put forth by Republican lawmakers, just make sure that where schools receive financial assistance from the government, secondary schools receive financial assistance, those schools then can't deny equal access to resources or time, say the ability to have student-led clubs on the basis of religious, political, or philosophical beliefs, or because of the content of their speech. So there can be free speech for student groups. What's important related to religion in particular is that the Equal Access Act specified that teachers cannot lead students in prayerful activities or religious activities, even though the students might have a student-led religious club. All right, what I've got for you now is something I'd like you to think about. It is, here we go. It's a poll. Is it constitutional? I put the link in the chat area. I'd like you just to take a couple of minutes to look at these questions. They're just 7 short questions, they're multiple choice. And I'd like you to share if you think that the practice described in the question is constitutional or unconstitutional, based upon what you've learned so far and what you might already know, what you might be bringing to this webinar. So just take a couple of minutes for that. I wish I had some music to play for you right now. Figure that out. Great, we've got 1 response already. Great, we've got 2 responses. We'll get a couple more. Great, let's take a look here what we've got. So in our responses, the first question was, is an after-school Christian club an unconstitutional establishment of religion? And unanimously, folks said, no, that's not an unconstitutional establishment of religion. Good. So remember the Equal Access Act? Great. So students can do that as long as it's student-led and student-run, and it's not during instructional times. After school, for example, as I mentioned here, great. If it goes for Christian clubs, if it goes for any other religious group, then as question 2 says, an after-school atheist club would have the same right to have a club, as long as, again, not during instructional time and it's student-led. Excellent. The next question, are clergy-led prayers at graduation an unconstitutional establishment of religion? So we had some differences of opinion here. Most of you said yes, that it is an unconstitutional establishment of religion. Some of you said, no, it's not. And some of you said, I don't know, which is a perfectly legitimate answer. Generally speaking, there was a case of having to do with this specific issue about clergy-led prayers at a graduation. And the Supreme Court found that it is an unconstitutional establishment of religion to have a specific person speaking. I think in that case, it was a rabbi who was speaking at a public school graduation in that particular case. Now, graduation, as I mentioned earlier, always becomes tricky because there are times when religious speakers, students might give religious speech at graduations. And the question is always, was it a school policy? Did the school enable it? Did the school orchestrate in any way that prayer or that religious speech given at a graduation? But clergy-led prayers generally, are considered an establishment of religion. Can students comment on their own religious beliefs in their assignments? An overwhelming number of you said yes, and that's true. Neither students nor teachers, as the Supreme Court said in the Tinker versus Des Moines case, which had to do with armbands that students wore in Mary Beth Tinker and her brother in protest of the Vietnam War. Students and teachers, they don't check all of their rights in at the schoolhouse gate. You still have your rights. You still are someone with your rights. However, there are limitations within the school environment. And for students to be able to comment on their own religious beliefs, they don't check that at the gate either. They can do that in their own assignments. There are limitations of a student being able to proselytize in the middle of class, for example, to the whole class. But if they're just commenting on their own religious beliefs in discussions or in a written assignment or a project, that's fine. They have the right to do that. Can teachers display symbols of their own religious beliefs in the classroom? And a majority of you said no, and some of you said yes, and some I don't know. I would say here, generally speaking, no. I think the majority of you are correct, that would be considered an establishment of religion. We'll talk about some instances where that might be a little bit different with regard to teachers' own personal jewelry, but let's take a look at just the facts as we have them here. Displaying symbols of your own religious beliefs in the classroom would be considered an establishment of religion under all the rules that we've learned so far. How about religious charities? Can religious charities work with schools to collect canned goods, like think of the Salvation Army, something like that, from students at holiday times? Peg, did you have any comments on this particular one? In your understanding?
Yeah, this one is it's a little iffy, but it depends on what the religious charity is adding to the system. In other words, if they're just helping people, it should be fine. But if it requires anybody to receive the food to have to somehow be part of their particular religious system, then it would be much more challenging.
Right. And finally, should students ever participate in simulations of religious rituals as part of the curriculum? And most of you said no. And one or two of you wondered, and I put this on here, what's a simulation? I'm glad you asked what a simulation is. So a simulation is anything done, of course, in the classroom where students are enacting some kind of practice. You could have simulations of government practices, like a simulated constitutional convention, or a simulated legislative hearing, or I mentioned mock trial earlier, a simulation of a court case. That's great. When it comes to religious rituals, having students enact some kind of religious practice would be a violation of the Establishment Clause. Students shouldn't be enacting a religious belief, even if it's one that they might personally subscribe to, if they're required to do it as some part of an assignment, even if it's an extracurricular assignment, that has garnered some legal action by certain groups related to that practice. Paul, you had a question for us.
Yeah, I just have a quick clarification question, because this is quite interesting, because today in my world history class, we were going over feudalism, and I actually brought students up to do a simulation of the feudal hierarchy. And so you have, the king and queen, and then their nobles, and then the knights and the peasants. But then I also involved a priest the clergy, because they were part of that power dynamic. And the idea was the clergy was both tied to the king, but also independent and tied to the Pope as well. Does that mean that I should just exclude that clergy from our simulation? I mean, the student who came up was doing the sign of the cross when he was up there. He happened to be a Catholic student, but when he was talking to the king, he used it. And when you're talking about certain parts of history, right, it's all religion at that time, in terms of, there was no separation. How would you deal with that kind of a nuance, if possible?
That's a great question. Peg and I have talked about this many times in the past and I know you teach world history, US history. We also have a middle school. We have middle school teachers here too with us. And in middle school, especially in 6th and 7th grade, what you just said comes up quite a bit, which is it's impossible to teach about world history. It's also impossible to teach about US history without, of course, talking about religion and making sure, and religion was so integrated into society. You talked about medieval society. Well, I mean, religion was integrated into governance. It was integrated into almost every facet of society. So it's really impossible to, try to somehow cleanly separate it all out. So I don't think that is necessarily a simulation of a religious practice. One of the practices that comes up a lot, or that I should say stuck out in my mind, was a case. This goes back many, many years, but there's a case of a teacher who had students fast during the month of Ramadan in order to learn about Islam. And the teacher had, good intentions in doing that, wanting the students to understand Islam. But that's an example of actually simulating an actual religious practice. But having students to understand the role of religion in medieval society, you want to make sure that you have an academic, sort of a secular academic purpose for doing that. And then make sure that in enacting that then the students aren't advocating for the religious belief or against that religious belief. They're not doing any kind of advocacy in what they're enacting. What do you think, Peg?
It's one of those gray areas is
Mhm.
what I would say, but at the same time, there is a shift during the Middle Ages in England, so that the king does have power over the church. And that's the whole Henry VIII thing, you know, the whole 9 yards there. And but before that, it's the clergy that have power over a whole segment of the church. It's the clergy and the bishops and all of that kind of thing, and they don't do always what the king wants. And so that really would be part of, I guess, what I was thinking when you were talking about the issue. And it's but there was no, you know, Social Security in those days. There was no government provided allotments to help out the people who are very poor and don't have enough to eat. It's the church that comes in to do that stuff, and they're the only established part of the society that does it. Now, that doesn't mean occasionally others don't step in, but it's part of the established processes for being in the village or in a moderate sized town. It would be to help the lower income people. So having them understand that, I would have interrupted, you know, them, the layers of power are there for sure. But how much of it is because there aren't social services available, I think might have been a good nuance for the students to understand.
Mhm.
And it would be less about religion and more about, you know, people get hungry no matter where they are.
Yeah, that's a good example. So as Peg mentioned, yeah, it is kind of it can be kind of a gray area, but it is, of course, part of the curriculum. In the time that we have remaining, I just want to highlight these cases that I mentioned before. So this case from 2014, because they're really critically important now for our purposes here. The Town of Greece versus Galloway case from 2014 had to do with legislative prayers at a city council. And you have pictures here of the activists from both sides who showed up at the Supreme Court. At the top, they were activists for the city council to continue their practice of prayers that were, you know, brought in people from different prayer groups, but primarily Christian groups. So it was really de facto Christian majority speakers who came to give the prayers. And at the bottom, you see someone who believed that that was an enactment of theocracy. The Supreme Court said that legislative prayer has become part of our heritage and tradition, and that heritage and tradition principle would become increasingly important for the next case that we're going to talk about, and is really why we're going to see the Town of Greece versus Galloway case has become really the foundational case for how this particular Supreme Court that we now have is looking at religious issues and religion in schools. And that's this case of the football coach in Washington. His name was Kennedy. I don't remember his first name. And he was disciplined by his school district for going to the 50-yard line during, or I should say at the end of football games when he was still on duty, and silently praying, like you see him demonstrating here. That's him. He's demonstrating how he prayed at the 50-yard line. Oftentimes, students would gather around him to pray with him. He didn't direct them to do that, but he had gotten in some hot water with the school district before for actually leading students in prayers in the locker room, for example, and taking more of an active role in gathering students for prayer. And the district warned him that, you know, you're opening up the district, you're exposing us to liability. Someone's going to file a establishment clause lawsuit based upon what you're doing. He felt a strong conviction to continue his 50-yard line prayers. The school offered, you can go pray in private. We're not saying you can't pray, you just can't do it in the presence of the students. Because as we saw in those school prayer cases, what's done in the presence of the students becomes critically important. The Supreme Court, he also sought some publicity in local media to try to get support for what he was doing at the 50-yard line. And when the case finally wound its way to the Supreme Court, he was challenging, he was let go from his job. And this goes back to 2015, because he continued to pray at the 50-yard line when the school district told him not to. The Supreme Court this last summer found that his activity of praying at the 50-yard line was a personal religious observance, and therefore it was not coercive to students in any way. And because it wasn't coercive, it should be allowed and was not a violation, well, of the Establishment Clause. But the court has, over the last many years, and especially in this case, has been taking using the free exercise clause to protect this coach's, for example, his free exercise rights as being the rights that determine, they're determinative in the case. They determine what the outcome of the case should be, much more than the Establishment Clause should determine. Having said that, however, this is Justice Neil Gorsuch, who wrote the majority opinion. He said in his opinion that it's apparent that this court, Supreme Court, long ago abandoned the Lemon test. So remember that three-pronged test and the endorsement test, those have long been abandoned. And this case, which I have here, American Legion, which is a plurality opinion. So it's not really the strongest opinion to use, but on a very limited issue related to monuments that the government might put up, that in that case was a cross to memorialize veterans of those who died in World War I. Based on those principles and the Town of Greece versus Galloway case, that means history and tradition, the prayers that this coach did are personal religious observances. In her dissent, Justice Sonia Sotomayor said, pointed out really that, well, Lemon hasn't really been overturned. Justice Gorsuch said that it was long ago abandoned, but it hasn't been overturned. But the court actually, in her dissent, says it is overturned as of this case. So that Lemon test is no longer really, we can't rely on it at all when we're looking at what schools will do with regard to the Establishment Clause. And she said that in her dissent, in other parts of her dissent, saying specifically that this case really abandons what the courts have taken decades to articulate, to separate church and state within schools and to protect the rights of students within schools from not feeling like they are other because they don't share the religious beliefs of the authorities in the school. And a coach is an authority, just like a teacher or administrator is an authority. And schools in those school prayer cases really pointed out how schools have kind of an inherent coercive power because of the strength of the influence, the authority invested in the school as a state actor and its employees as state actors. So in this case, now what we're seeing is an opening up of issues. And I mentioned there's going to be tests of the limits of that. And as of today, Coach Kennedy has gotten his job back at the school in Washington. There's still questions about attorney's fees, because he had a number of attorneys working for him and law firms that worked for him that gave some, donated their time, but he raised money in order to take this case to the Supreme Court. And there's some technical issues, as far as I understand, related to the terms of him coming back, but he got his job back. He's been reinstated. So that's what happened with this particular case. But also just last week, there was a case that went, or I should say an incident that went viral where a school was, some teachers in the school, or at least one teacher you can hear, was praying very, very strongly. And somehow it was being broadcast outside of the school and their outside intercom system. Someone filmed it with their phone and it went viral on the internet. Now the school dealt with it by clarifying for the community that no students were present when the prayer was being said, and the teachers were there voluntarily in their own, sort of teachers' prayer group, I guess, which is another thing that teachers can do as long as it's not an instructional time or in the presence of students, can pray or have a, say a prayer or have a religious meeting of some sort. So it's interesting, even after this Kennedy case that got rid of the lemon test, or I guess for good, schools are still concerned, and they still are preserving this idea of, as long as students aren't present for this religious activity or this prayer, and it's voluntary among the adults, then we want to reassure the community that the school isn't imposing any kind of religious practice or belief on students. So that's one recent issue, and we'll see other ways in which the court's decision this summer might be subject to stress tests. So with the time, we have a couple more minutes. You can always reach out to either Peg or myself if you have any additional questions, but I wanted to make sure that we have some time here today to deal with some of the issues that we mentioned at the beginning. Let's see, which have to do with issues that have come up in your schools. Let's see, I'll leave that here. Let me. And I wanted to reassure you that of course, everything that you wrote is anonymous. So some of the issues related to schools, someone wrote that says, I do not feel safe wearing my religious outfit at work because I'm afraid that people might think I'm promoting a religion. That's a really good question. I think for me, this comes down to what religious outfit means. I mentioned jewelry earlier, and generally speaking, courts have found, and also experts in First Amendment law have found that we're allowed to wear, a personal item like a cross or a Star of David or something like that. That's jewelry. It can't be something that's obtrusive. So if it's something that's non-obtrusive, that doesn't look like you're trying to impose something on students, and as long as it's not proselytizing, like a message, a religious message or an anti-religious message, then that wouldn't be considered promotion of religion or an unconstitutional denigration of religion. So that would be my understanding of that issue.
Damon,
Yes, feel free, Peg, jump in.
We talked about this one before the audience got here. I was thinking possibly it was a hijab that was involved. And I know of teachers who have worn hijabs and it was not a problem at all, but it would be one where there would be identification of a particular faith group, in that it's not something that's part of, well, a scarf was part of Christianity, especially anywhere going into church, but not to be at the school necessarily. But what I'd like to hear from the audience, the others here, what did they think about teachers who are Muslim that want to have a hijab?
And can I just say real quick, it is 5:15, and so that was where we were going to end the webinar. If you have to go, you please don't feel like you're insulting us if you just jump off. I'm really glad to have all of you here with us today. I'm glad. I hope this was helpful for you in understanding what's happening now in schools and some of the history and how the First Amendment applies. But feel free to stay on. We'll discuss some more of these issues as we continue. But thanks a lot, everybody.
Thank you.
And then Peg's pending question. So thinking about hijabs for people in public schools or teachers in public schools. And you could write comments in the chat area if you would like. I think someone's speaking, but I'm sorry,